Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Jeff Karp, Justice of the Superior Court, now sitting in Lawrence within the Court of the County of Essex, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, and this most honorable court. Court is now open. Please be seated.
Good morning, Your Honor.
Good morning.
March 26, 2026, Court in 2, Lawrence Superior Court. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311. Scheduled today for continued jury waive trial. Could counsel please identify themselves?
Good morning, Your Honor. James Gubitose.
Good morning.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor. Martha Cooley for the defendant, Kelsey Fitzsimmons.
Good morning. Good morning, Ms. Fitzsimmons.
Good morning, Your Honor.
Good morning, Your Honor. Timothy Bradl. With me is Ms. Healy. Assassin, Mr. Leonard.
Good morning, everyone. Thanks. You can have a seat. All right, so you folks ready to proceed?
Yes.
All right. I don't say this for the attorneys who know this, but because the government, the prosecution has the burden, they go last. The defense goes first in their closing. And Mr. Bradl, you may proceed.
Thank you very much, Your Honor. May it please the court.
Yeah.
Counsel, ladies and gentlemen. Your Honor, June 30th, 2025 was the worst day in Kelsey Fitzsimmons' life. Her whole world imploded. Her fiance betrayed her. Her baby was being taken away. She was going to lose her house, her job. It was an incredible confluence of tragedy that was visited upon her that day. That day was about her, and she decided in the midst of what you saw testified to here, she decided to end her life. Patrick Noonan, when he came back up those stairs, Your Honor, walked into a suicide in progress. That gun was nowhere near him. That gun was already pointed at Ms. Fitzsimmons' temple by Ms. Fitzsimmons. She was a couple steps into the room. Officer Noonan, a gung-ho cop, highly trained, a SWAT guy. He'd already been ginned up all afternoon by the insane, ludicrous statements of Justin Elaine. He had that in his head. He walked in, and like all of us are susceptible to, he made a mistake. He shot too quick. He reacted too quickly. And instantly, he realized that he had to adjust the narrative. And that was easy, to just add 6 words to the equation, Your Honor. He said, words to the effect, she pointed the gun at me. 6 words. What did those words do at that time period? Those words made him the victim. Those words made him the hero. And those words, most important, made him untouchable. Those words were a defense for his future, his life, his reputation, and they were conveyed to a very willing audience. His colleagues, his brothers, his family, the investigators on the case. So that's really what happened here, Your Honor, and it is a tragedy, and it is something that should not result in any further harm to Ms. Fitzsimmons. This should be over. This should be an acquittal, Your Honor. I want to talk to you about a few of the elements that I know you're going to be concerned about. So first thing I want to talk about, Judge, is the lack of motive and the lack of intent. because when it gets down to brass tacks, you know, I know that you're going to look at the law, you're going to look at the credibility determinations, and you're going to make your judgment. And here, this case fails the Commonwealth ship founders on the rocks of lack of motive and lack of intent. Let's talk about motive. Everything in life is motive. And it's ironic that, you know, us lawyers always say, oh, well, you don't need to prove motive. But you really kind of do. It's meant not be an element of the crime, but motive is everything in this business, Your Honor. Let's look at the motive or lack of motive. Fitzsimmons and Noonan are colleagues. They have already bonded over shared tragedies, shared experiences. They were okay with each other. They were friends. Kelsey thought well of him, and she thought he thought well of her. She knows he has a family. She knows who his family is. She's not going to harm this guy. She knows, Your Honor, that he didn't do this to her. She knows that Justin Elaine did this to her. And she's probably most important, she's been in those shoes before, serving restraining orders. She knows she's just a messenger. She knows he's just a messenger. This was the worst moment of her life, and she wanted to end her life. And how did she want to do it? She wanted to do it alone. She didn't want to involve these officers because she knew this was a selfish act. She came in here, and ironically, the most credible evidence that came into this case, Your Honor, was from the one person that didn't have to testify. And she came in here and she chose to testify. And she waived her rights and she testified. And she showed, Your Honor, that she's a moral person. She's a caring person. You will sit down and you'll deliberate, and you'll be drawing the inevitable conclusion that Kelsey Fitzsimmons is a moral person. You have to contrast that with the callous treatment of this case from the other side. Hey, we're going to go serve an order on Kelsey Fitzsimmons. Her ex-fiance got an order on her, on Kelsey. Let's go serve an order. The answer, sounds good. Let's go. Talks to his neighbor. Oh yeah, I'm the shooter. I'm the shooter. She's a whack job. So you have to take these credibility determinations into account. And I know you're a gentleman, but you have to get down to brass tacks on who's who here, Your Honor. What else shows you that she's a moral person? She doesn't want to involve these guys. She's trying to get rid of them. She says, oh, the guns are over here, so she can go where they really are. She keeps trying to give Houston and Noonan baby things to bring downstairs. She's trying to get rid of them. She's trying to get them away from her. She wants to do this on her own. She doesn't want to have some sort of a situation where she gets shot by one of her colleagues and friends. It's understandable because she's a moral person. She waits for her chance. She gets to her room. There's a distraction downstairs. She doesn't know what's going on because she's focused on the job she's trying to do here, the tragic, awful thing that she's trying to do to herself. That's how you know she's telling the truth, Your Honor. You saw in the room, and I'll show it to you in a minute, the chest that she got the gun from, it's a chest on the floor. It has one of those pretty substantial lids that you would have to flip up to get the gun, locate the gun, pick the gun out of the 4 guns, and stand up. If Noonan was standing right there in the door frame, that would have never happened. All those events, that little series of events, he would have been able to stop it. He would have stopped it. It tells you that he's down the steps. He was interested in the distraction downstairs. He saw Kelsey folding some baby clothes, getting baby things ready. His attention, it's human nature. His attention was drawn to go back down the stairs. He walked down the stairs 2 or 3 steps, 4 steps, whatever. And Kelsey told you, Straight up, that was my chance. And she took it, and she went in the chest. Exhibit 51, Your Honor, I'll show you right now. She went in that chest, flipped up that lid, got the gun, stood up. She told you, again, she's a moral person. She tried to keep the gun concealed. She made the motion like this, Your Honor, where she put the gun like this, and she kind of walked over here because she didn't want the police to see her with a gun. She held the gun to her stomach area. She walked to a clear area, and she put the gun to her head. And that's what I mean when I say Officer Noonan came back up the stairs, and what did he walk into? He didn't walk into some Rambo woman trying to shoot him in the face. He walked into Kelsey, who you now know a little bit from her testimony. He walked into Kelsey's room, and Kelsey had a gun to her head, and he walked into a suicide in progress, Your Honor. And the man that had just been holding her baby, that she chose to hold her baby, that she chose to feed her baby, walked into her suicide in progress. The gun was nowhere near Noonan. There was no threat to Noonan. And the law says that an officer may not use deadly force on someone who is exhibiting a danger only to themselves. And that's offered to Your Honor twofold, in the sense that it shows that this was not a reasonable use of force, and it shows you that his knowledge of that statute, as he said on the stand, gives him a motive to lie. He knows that this is not a good shooting. He knows this is not a clean shooting. And that gives him a motive here, Your Honor. And like all of us, we all make mistakes. He overreacted and he shot. He had the look on his face, panic, flustered, he shot. He had made a mistake by leaving her there, walked down the steps, a few steps, and that gave her the chance. And when he did this, he knew immediately, Your Honor, that he had to adjust the narrative. Filtered through the legal lens, Your Honor, that tells us that Kelsey had no intent. She had no intent to harm Noonan. There's no assault here because she didn't have the intent to do so. As the fact finder, you can consider everything I said about motive, that she lacked any motive to harm this gentleman. In fact, it was the opposite. She thought well of him. She knew Justin did this to her. She had just trusted him with her baby, and she had tried several times to get these officers away from the situation. No intent to harm him, no motive driving her mindset to do so. Reasonable doubt, burden of proof, Your Honor. Where the evidence supports a reasonable and more plausible alternative, and that's shown here by Kelsey's testimony, it cannot be said that the Commonwealth has proven their case beyond a reasonable doubt. There is reasonable doubt. When there are two plausible versions of what happened, that itself is reasonable doubt. The versions themselves, Your Honor, show reasonable doubt. Kelsey's version rings true. Noonan's version is all over the place. Noonan's version is contradicted by the strong consensus of everybody else in the house. Noonan portrays a couple different stories, but if you want to pick one where it's this drawn out potential gun battle, where she's backpedaling, sidestepping, tapping, racking, there's commands going on, that takes time. It takes time for me even to say it. Never mind do it. And that's belied by everything everybody else in the house says. Everyone else says, Kelsey, no, 2 shots in quick succession, bam, bam. That does not fit with what Noonan said happened. So on that alone, Your Honor, as a fact finder, I suggest that your duty is accomplished quickly, because there are two extremely divergent versions of this event. And Noonan's version has changed itself. Noonan's version is inconsistent with who you now know Kelsey is as a person. It's self-serving. And like I said, it makes him untouchable. And when you judge it against everyone in the house, he's the only one with the Rambo story. Everyone else has what Kelsey says. He walks into a suicide in progress. He sees it. He reacts. Kelsey, no. Kelsey, no. Bam, bam. Brain freeze. Mistake. Has to cover it up immediately. What else do we have? You know, when you're a fact finder, Your Honor, you want to look for corroboration. What's the corroboration on either side of this thing? Or lack of corroboration, which is what really it is here. The big one, the big elephant in the room is that this department has no body cameras. We wouldn't even be here if they had body cameras. There's no evidence other than people's words. He said versus she said. That's oftentimes, almost all the time, not a good place to start for the Commonwealth. How many of these guys didn't do reports? What's up with that? Why didn't Trooper Strong put the body camera video on the witness he's interviewing? There's no science. The testimony of everyone else in the house shatters his narrative. Kelsey Fitzsimmons has been blessed. She should be dead 2 times over, by her own hand and by the hand of Officer Noonan, who shot too quick. She's blessed. She's here today, and she has a new lease on life. And maybe that's why the investigation is what it is. And maybe that's why Noonan's story is so sloppy, because nobody expected her to be here today to tell her truth. But she is, Your Honor. And as the fact finder, I want to respectfully ask you to consider the evidence, consider the lack of motive, the lack of intent, the inconsistencies. The credibility contest is firmly in her camp. She came in here and she told you what happened. Unvarnished truth. And I ask you to find her not guilty. Thank you, Your Honor. Thank you.
Yes.
I mean,
Yes.
every piece of credible evidence in this case proves one thing, that she's guilty. All the testimony, the scientific evidence, the physical evidence, the demonstrative evidence, everything points to one conclusion: she is guilty. Even her own testimony proves she's guilty, because it's impossible to have happened the way she said it. It is scientifically, mechanically impossible for it to happen the way she said it. Her story is that she grabbed a gun, put it to her head, pulled the trigger, and it clicked. The chamber was empty. That's what her story is. And that's what Officer Noonan's story is, too. She pulled the trigger, click, nothing came out. There wasn't a round in the chamber. She even said, she told everybody how stupid I am. I tried to kill myself with an empty gun. But what do we know about the gun? What do we know about her gun? Because after she went to the floor, Lieutenant David picked it up, put it on the bed. Officer Noonan picked it up and put it on the table. And then Officer Karp came in the room. And what happened then? Officer Noonan said, secure that gun, make it safe. And so what did he do? He took the gun, he found that black box, the safe. He made sure that was empty. He turned it over. He pulled out the magazine that you can see right here. He opened the chamber, and there was a round in the chamber. He dumped it out into this safe and put the firearm in there. And then they stood watch on that until State Trooper Bonasara took it back in the lab. That magazine that you have in evidence contains 16 rounds. It was a 17-round capacity gun. It contained 16 rounds, plus the one that was in the chamber. 17 rounds. As we know, there are only two ways to get a bullet into the chamber. One is if there's already a bullet in the chamber, someone pulls the trigger, a bullet comes out, the casing comes out, the chamber's open, the spring allows another bullet to come up. That's one way, and we know that didn't happen here. The gun didn't fire because the chamber was empty. The only way a bullet gets in this chamber, other than that way, is if someone racks the gun. She said she didn't rack the gun, but there was a bullet in the chamber. She did rack the gun. What did Officer Noonan say? She pulled the trigger. Nothing happened. She stepped back, tap racked, tried again, didn't do it. Tap racked again, pulled it, and that's when he fired. She put a round in that chamber. That's the only way it got there. Her story can't be true. She got up on that stand and she lied to you. It's scientifically and physically impossible for her story to have happened the way she said it. That's what the evidence shows. But she didn't just lie to you then. She lied again. She lied at the scene about where the guns were. And she admitted that, and I understand that, right? And she said she lied to the police because she decided to kill herself. But when did she say she said that? They had been to the house. They had talked to her, according to her. She now started contemplating all of the ramifications of what's going to happen to her. Because she's losing her life, her job, her son is being taken away, all of these things. And so she's going that over her head. And then minutes later, as she's walking through the house, She says, my gun's in the basement, because that's the time she made the decision to kill herself. Later on. And we know that's a lie. We know that's a lie because what was one of the first things they asked her when they went to that house? They asked her to put the baby down because they were concerned for the baby, told her the restraining order, what the parameters were, and asked her where your guns are. When she was still sitting on the sofa. They weren't waiting to ask that question so she was already walking around the house. No way. And what did she say there? They're in the basement. And we know she said it there before she moved around the house, which is untrue, because her friend, Officer Houston, who was invited to her wedding, says it also. He says, Sergeant Daly asked. And then remember what he said? He said, I was in the living room, she was sitting down, and then I saw a gun case on the other sofa. And so I opened it up to see. And she said again, I already told you the guns are in the basement. Now, why at that point did she say that? We don't know. She didn't tell us because she lied to us about why she said it later, because we know she didn't say it later. So she lied again. You can't trust her. She also lied about knowing that her mom was in the house. She was upstairs. The officer, Noonan, I think it was, Noonan heard an older woman's voice down there and said, who is that? She says, I have no idea. She doesn't know her own mother's voice, her best friend that she just talked to come to the house. And she said she didn't know whose voice it was. Another lie. She said on the stand yesterday that she didn't know Justin was in the house. And we know that's a lie too, because what happened when the three of them were upstairs? It's Noonan, it's Houston, and it's the defendant. She hears him downstairs. Houston hears him downstairs, and she says, keep him away from me. I don't want him in my house, or something to that effect. And that's when Houston went down to make sure he wasn't coming up and went to the basement. She knew he was in the house. She absolutely did, and she lied to you when she said she didn't yesterday. And you know what else she lied about? Something so simple, but it shows who she is. The restraining order. She said, the restraining order was taking my dog away. It says it. It doesn't say that. Nothing about the dog in there. I could go on about the lies, but I want to talk about the credible evidence. The credible evidence in this case. When Lieutenant Daly got a call, actually got a visit from Justin Elaine when he was in the lobby of the PD. And Justin told him he got a 209A against Kelsey Fitzsimmons. And Detective Daly knew that she had been sectioned before, that she had guns, that they were taking the child away from her for a period of time. And so what did he do? He called Officer Houston. He asked Houston to call Daly to meet up. And why did he say he did that? He said because those two are cool, calm, and collected. They don't panic. They keep things calm. That's what he said. And that's why when he called Houston, he said, can you call Daly? We got to do this. And so he wants you to believe, defense counsel, that Pat Noonan was cavalier about, oh, okay, sounds good, we have to serve a restraining order. But that's not what happened. He was mischaracterizing it, and I hope you remember, in the grand jury minutes, because Houston had called Pat and said, hey, we got to serve an order, can you meet me by the school? And Pat said, sounds good. It wasn't until he got over there, it wasn't until Lieutenant Daly was there that they learned really what they were going to do. And they went over there. And defense counsel asked Daly, you guys were cavalier about it, you knew her, weren't worried about the guns, all this stuff. And Lieutenant Daly said, no. No. His quote was, we had an increased level of diligence. Everyone was more on point because they did know what they were walking They did know. They did know that she had been sectioned before. They did know there was going to be a baby in the house. They did know that she had guns. They did know at that point that she had parked her car far away. This is all going to what they were thinking at that point. They did know all those things. And they did know Justin's concerns. He said, according to Lieutenant Daly, I'm worried she's going to kill the baby, kill herself, and kill someone else. So that's what they were thinking when they went into this house. That's the credible evidence when they went in there. And what did they do when they went in there? They sat her down, and they allowed her, or maybe they asked her, I can't remember, to go around and get some stuff for the baby because she knew Justin was coming to get the baby. And they were in her pocket the whole time. They followed her around the house, at least two of them, while she did that. And you know that because even Officer Houston said, I was in her pocket. We went into the kitchen, and I noticed there were butcher blocks with knives on it, and they were concerned. There was no chance they were leaving her alone. No chance they were leaving her alone. Officer Noonan. Officer Noonan. All of the testimony that you've heard about Officer Noonan, even from the defendant, he's a gentleman, he's experienced, he is by the book, and his training and experience starting in the military, through boot camp, through security forces school, security forces squadron, with all the training he had, and Humvees and helicopters, and the SWAT team, 2 times a month training, clearing rooms, clearing buildings, hostage situations, missing persons, no-shoot scenarios, twice a month, and a 40-hour block every year. For over a decade, he did that. And he moved to Lawrence, as far as the department goes, because it was busier, and he had more experience. He was cool, calm, and collected. There's no doubt about that. And to say when they're upstairs, and he walks away and leaves her alone because he heard a commotion that Officer Houston was going to attend to, is a joke. It really is. Now, how do you know they were going by the book at that point? And how do you know they were vigilant? Because they followed around everywhere. Because both Houston and Officer Noonan said she kept handing us things, and we kept putting them down. We wanted our hands free. Because they were ready for whatever happened. Hoping nothing did, but ready for whatever happened. So at some point, Houston and Noonan are upstairs, and the defendant goes into her room. And she hears Justin, and Houston goes down to keep the peace to make sure he's there. And Officer Noonan is watching her. He's watching her. And she's on one knee. And she lunges, and she disappears. And she emerges with this, pointing at him like she is trained to do. Click at his face. And what does he see next? He draws his weapon, and he says his testimony, it kind of slowed down. The whole thing took maybe 4 seconds, maybe even 3.5 seconds. His training has kicked in. His experience has kicked in. It was a surprise to him, certainly, because she got the drop on him. And why did she do this? Who knows? Maybe he's right. Maybe she was going through him to get to Justin. Maybe she was just so upset she was going to shoot anybody in front of her. Maybe she wanted him to shoot her. We don't know because she lied about it. We don't know. But the fact is, She started to shake, she started to tremble, and she lunged for the gun that he couldn't see. And what happened after she flipped? She stepped back, and now he knows, based on his training experience and the clip, there is not a round in the chamber. He knows that, and so he doesn't shoot. According to the defendant's testimony, he had every right to shoot at that point. And you know what? He actually did. He had a right to shoot her at that point. If you point a gun at a cop and pull the trigger, they get to shoot. But he didn't, because he was controlled and disciplined. That's the way his career went. And so she steps back, tap, crack, and tries to do it. He doesn't shoot her then. And what's he doing at this point? Kelsey, no, Kelsey, no. Because he knows the threat isn't there, really, because there still wasn't one in the chamber. Kelsey, no, Kelsey, no. He is being disciplined like we wish every police officer, every law enforcement agent in this country was. He should be applauded for his actions on that day. Tap rack again. Now he knows one's in the chamber. Threat's on. She starts to raise it, and he shoots. He shoots twice to stop the threat. He stopped shooting when the threat was neutralized. Defense counsel, during his cross-examination, well, you would have unloaded her gun. He goes, no, that's not what you do. You shoot until the threat is neutralized. She was now down on the ground. But his training and experience are still taking over at this point, because what does he do? He still has his gun on her, because the gun's still there. He can't see it. Lieutenant Daly comes in, Lieutenant Houston comes up, and what does Officer Houston say that he sees when he comes upstairs? That Officer Noonan is standing there with the gun low and ready. His training is still taking place. He's still doing what he was trained to do. The gun is put on the bed. He's calm and collected. He takes the gun and moves it away so people are safe. He's deliberate in those actions. When it's away from her, he starts to tend to her. Officer Core comes in, and he asks Officer Core to make the gun safe. He's cool, calm, and collected. That's what Lieutenant Daly expected, and that's what he was. He didn't make a mistake. That's what the credible evidence shows. And what did he say to Officer Houston after? And this just goes to state of mind, I know. That she pointed the gun at me, and it clipped. And she tried to rack him up. Immediately after, this wasn't him saving his hide or protecting himself. Seconds after this happened, that's what he said. Every piece of credible evidence points to the unmistakable fact that she is guilty. Every piece of physical evidence, scientific evidence, mechanical evidence, every piece of testimony from Daly to Houston to Core, even Lauren Page, the mother, even the defendant corroborates what Officer Noonan says. Every piece. Your Honor, I would suggest to you there is only one fair and just verdict in this case, and that is guilty. Thank you.
Maybe for a sidebar.
I'd like to speak with counsel anyway at sidebar for scheduling purposes. While you folks are returning, counsel are returning to counsel table, I'm just going to, we went to sidebar for two reasons. One was Mr. Bradl has a series of objections that he'd like to lodge about the Commonwealth's closing, which I'm going to give you an opportunity to do in open court. with the Commonwealth in open court responding. And also I went over the schedule. So as I told counsel, my intention is to take as long of a period of time as I need to reach a verdict, provide the court staff and counsel with 30 minutes notice, and come out and announce my verdict, some of my reasoning here in public, and whatever time that works. In other words, if it's during our traditional lunch break, so be it. You folks will have a half hour of notice, which means that you'll be able to go and have coffee or lunch or whatever, as long as you can get back here. All right, so that's how we've worked that out. We also discussed at sidebar the fact that in a jury trial, we never provide the jurors with ammunition and a firearm, even with the trigger block at the same time. So my intention is that Mr. Ruane, our assistant clerk, will keep possession of the ammunition, and the firearm will come back in chambers with me, along with the other exhibits. When and if I need the ammunition, will be switched out. All right. Okay. Globally, have I said in open court what we discussed?
Yes.
Okay. All right. So Mr. Bradl, I'll hear you on the objections.
Thank you, Your Honor.
So Judge, traditionally, we do this at sidebar, but as you mentioned, we don't have a fact finder here that we need to talk off to the side to. So in open court, I'm happy to do this. Sure. Yep, I'll go back over everything I said at sidebar, Your Honor. Judge, the first objections I have to counsel's closing argument center on ballistics issues. The first part is that counsel picked up the gun and used it 3 times. Prior to that, counsel provided what I would consider to be expert testimony on the operation of the gun. I think it exceeded the scope of what Detective Bonasaro talked about. He said that it had to be a scientific certainty that this gun was racked by Kelsey Fitzsimmons. Mischaracterizes the defense position that we're not saying necessarily that it did or didn't happen. We said that Kelsey Fitzsimmons didn't rack the firearm. And we have a completely different version of events. So no one's saying that it didn't happen. We're saying that Kelsey didn't do it. And to characterize it like, that it had to be racked by Kelsey Fitzsimmons is not fair argument, and it mischaracterizes the state of the evidence. The second objection relative to ballistics, Your Honor, is that counsel was acting out. I believe it was the second time he picked up the firearm. Counsel was acting out on Noonan's story that Ms. Fitzsimmons had accessed the firearm from the chest and picked it up to point it at Noonan's face. And on Noonan's testimony, she just pulled the trigger and it clicked. Counsel's acting it out. Prior to pulling the trigger, counsel racked the firearm and then pulled the trigger. And that's not what happened on even Noonan's testimony.
I'm happy to allow you to make a record, but the fact that there's 2 different versions of what folks testified about is fair game. What the issue right now is whether the Commonwealth argued items that were not in evidence or attempted to draw inferences from items that were not in evidence. So the disagreement about the racking is just not before me.
Well, that's why I bring it up, though, Judge, because this racking issue has been brought up to the forefront, and he did something that is not part of the evidence. No one says that she racked the gun before the first shot, and that's what he did when he acted it out. So that's why it's a mischaracterization. I'll just rely on Your Honor's discretion.
But that's not what Mr. Gubitose did, though.
I did see him rack the firearm before he fired the second shot. He did it the second time, Your Honor.
Okay, I'm having trouble understanding. Again,
it's just that when you act out the testimony, you have to do it accurately, and you
Okay.
didn't.
But I'm going to say this in open court, and it won't be the last time I say it. Whether or not Officer Noonan exercised reasonable use of deadly force is not before me. That is not my decision.
I agree with you, and I say it on
And
credibility.
hold on, and whether the North Andover Police Department followed procedure in executing, serving this restraining order is not before me. Child custody is not before me. All right, visitation is not before me. What's before me is, has the Commonwealth proved beyond a reasonable doubt that the defendant pointed that firearm for any perceptible amount of time at Officer Noonan? Okay, so all of this is just not helpful.
And I offer it on credibility, though, Your Honor.
Okay.
Also, the Commonwealth said that on the scene, Ms. Fitzsimmons didn't say part of her story there, so therefore she's making it up. And whenever the Commonwealth tries to argue that somebody, a defendant, didn't say something, that's very dangerous ground for the Commonwealth, Your Honor, that the defendant is under no burden whatsoever to say anything, Your Honor. And here to suggest that she's lying because she didn't say part of her story when she's shot in the chest at the scene is unfair argument, but it also violates her right to remain silent. And it's an intrusion on that, so I would object to that. I ask you not to consider that, Your Honor.
Except that, Mr. Bradl, she waived her right to remain silent, right? She testified. So
At the scene, though, Judge.
Isn't it fair game for the Commonwealth to discuss the testimony that your client offered?
The testimony, yes, but he's saying that at the scene, she didn't say XYZ when she didn't have to say XYZ at the scene. And that's, the Commonwealth can only argue that when a defendant makes a comprehensive statement and leaves something out to my client that she wanted to kill someone else, which didn't happen. That was not the statement. So that's a very important, very dangerous, very unfair, very prejudicial misrepresentation of what was attributed to Justin Elaine in the lobby. She never said anything about killing someone else. He didn't even he didn't say that she said that. So I ask you to strike that and not consider it. And the last thing, Judge, about lying about the dog on the restraining order, Your Honor, that trying to take her dog. And it is in the complaint to the restraining order by Justin Elaine.
I know he's trying to do a second closing, but the evidence is what the evidence is.
Yeah, but Judge, you can't say, when you have the discovery on the point, you can't say that something is a lie when you have the papers that show it's not a lie. And the box was checked in the complaint to get her dog. So that's a mischaracterization of the evidence that needs to be corrected, Your Honor. And that's my last point. Thank you.
So, Commonwealth, from my perspective, with all due respect to Mr. Bradl, who's done a terrific job advocating for his client, I view that as nothing more than a rebuttal to the Commonwealth's closing. So I'll give you a few minutes to rebut these things. Let me say this, though. I don't believe that there was any evidence before me that Miss Fitzsimmons was sectioned previously. I think that the way I view the evidence is that this is what the police believed. It was part of their state of mind in serving it. But I'm at a loss, frankly, that, in other words, what I'm saying, Mr. Bradl, is out of all the items that you argued about the Commonwealth purportedly arguing something not in evidence, this sectioning, alleged sectioning that happened prior to this, there's no evidence of that before me. There's mention of it, and it goes to the officer's state of mind. So, and that's all that in fairness, that's all that you argued, Mr. Gubitose. But I guess what I was getting at is if there was anything at all that came close, that would have been it. But Mr. Gubitose, I'll give you a few minutes for your rebuttal to the rebuttal.
I don't think I trust you to have sifted through what's relevant, what's not relevant. The evidence is what the evidence is. Closings are not evidence. I would suggest to you that, yes, I do need to be heard, I guess. that I argued the evidence that came from the witness stand and from the exhibits to Rubanasaro absolutely describe the ways that a firearm works and how a round gets into the chamber, and I limited my explanation of that to what he described and the like. I don't need to make a second proposal. Thank you.
You just did that.
I'm a lawyer.
Okay, no, I respect that, both sides. All right, so at this point, why don't we, I said that I was going to step off for the gathering of the evidence. Let me not do that. I'd like the council to just make sure that all the evidence, the exhibits are in order. You'll note your contentment on both sides. If you folks can take a look at the verdict form as well. I don't know if you already have. It's not complicated, but do you want, Mr. Bradl, have you seen the verdict form?
No.
All right, so one of you, officer, do you mind? Officer?
Commonwealth is content with that.
Same.
All right, content with the verdict form, but we're still working on the exhibits.
Yeah,
right?
we'll wait a few minutes.
Yeah, that's fine. I just was checking with our court officers about the availability of this courtroom this afternoon, so that we're checking on that.
So 90, 96, and 97, 98. ADA Gubitose on behalf of the Commonwealth, is the Commonwealth content with the exhibits?
Yes.
Attorney Bradl on behalf of the defendant, is the defendant content with the exhibits?
Yes.
And that would be for both of you, exhibits number 1 through 98,
Correct.
correct?
Plus the chalk, Mr. Clerk.
Yes, and the jury instruction. Yes.
Okay, not 98, I thought we had, weren't there 100 exhibits?
No, 98.
Okay, all right. I'm sorry, okay. All right, so, and Mr. Wayne, I think it makes sense, as in a jury trial, for you to swear our court officers in.
Could you all raise your right hands? Do you solemnly swear that you will keep the court in some convenient place until he has agreed that you will not suffer any person to speak to him, nor speak to him yourselves, unless by order of the court, or to ask him if he has agreed? And when he has agreed, you will return him into court unless the court shall otherwise order, so help you God.
I do.
All right, we will stand in recess for my deliberation.
All rise, please.
Damn it. Just like that, we're on verdict watch. What did you think of the closings? I appreciated that neither side really did character assassination. And the judge told them yesterday not to, but that doesn't mean that they're going to listen. You know what I mean? I do appreciate that. I know that Bradl is pissed about the state, but I kind of think they just did what they needed to do. I don't think that they did anything wrong in their closing. It was pretty inflammatory. And the thing is, so was the defenses. I mean, they pointed out, lies multiple times made by Noonan, and then the defense did the same thing for Kelsey. I mean, it's just, that's what's going to happen. The thing we have to remember is that closing statements are not evidence, and the judge well knows that. One of the things that the state's case has completely just ignored is the potential for tampering of Kelsey's gun after she was shot. I think that's quite glaring, and I don't doubt that the judge will notice it. I mean, yeah, the gun was racked. There was a bullet in the chamber, but we don't actually know who put it there. And there were a minimum of 4 people who touched that gun in that room. Kelsey, and then after she was shot, Daly, Noonan, the shooter, who should never have touched that gun, and Karp, who was told to secure the gun. So we know the gun was racked, but we don't know by who. And that is one thing that the state said in their closing that I do think was pretty questionable, when they said scientifically it could not have been anyone but Kelsey Fitzsimmons who racked that gun. And that is a lie. We don't know who racked the gun. The judge, she's charged with aggravated assault with a deadly weapon. He could convict her of that. That's a felony. He could convict her of a lesser simple assault, which is a misdemeanor. Or he can exonerate her. Those are his choices. Kind of in the middle. Kind of thinking she might get a misdemeanor assault. But I don't know. I want her to be acquitted. But the fact that she admits having a firearm in the presence of a police officer as a police officer is concerning. And lying about the guns, where the guns in the house were, is concerning. Those are things that Kelsey did do, that she herself admits. We'll see. I will never, ever understand why, when the police went into that house, they didn't immediately secure the guns. They took her word for it that they were in the basement. They didn't even check. Right. She lied about the gun. Is the judge a gun guy? In 4 seconds, she couldn't do shot, rack, shot. Right. Agreed. Well, I'm sure he knows how to do it now, because it's been demonstrated enough times in court at this point. But yeah, I don't know if the judge is a gun guy, Bethy, but I would imagine that he tries that out, because the defense is right. The timing doesn't fit at all. Just Noonan's own statement doesn't fit. His testimony said the whole thing took 4 seconds, and then he listed a whole bunch of maneuvers and stances that Kelsey did, and racking the gun twice, and pulling the trigger. You know what I'm saying? Takes more than 4 seconds to do all that stuff. I don't think the judge is stupid, and I bet he times it. I would time it. Yeah, and they let Justin in the basement. They let him in the house. They did everything wrong in this call. Everything. And then Kelsey gets shot and it's all her fault. She's not the reason they were at her house. That was Justin and his BS stories, which completely are uncorroborated. Did anybody sit on that stand and tell you that they heard Kelsey say all the things that Justin said he said? He said that she said? No, they did not have anyone corroborate that. I think you're right, Red. I think it's very possible that she may get a charge with a sentence of time served or something. I want her to be exonerated. I'm not sure she will be, because some of her behavior was very unwise and unsafe, and made her unsafe and made the officers unsafe. Now, the police aren't on trial in this trial, but I wish they were, because they fucked this up in a big way. This is their way of covering it, is by literally destroying Kelsey's life. So we are on jury watch with a judge. Never done this before. He keeps giving little hints, though. Yesterday, he thought they'd be back at 2 p.m. Eastern. Then he said, even if I'm back during our usual lunch break, oh well. And there's going to be 30 minutes notice. Yeah, Red, I know that part absolutely made me sick when he said that the police should be applauded for how they handled this. I mean, come on, man. That's really taking it somewhere, isn't it? All righty. Well, we shall be on jury watch. The stream will be live. I will be keeping tabs on any updates so that we will be able to watch the verdict when it comes in. Thanks for joining me for this trial. It's really been very interesting. I've enjoyed watching a bench trial a lot. It's powerful stuff. So we'll be back.
Good afternoon. We're on record on the Kelsey Fitzsimmons matter, docket 2025-77 CR 311. All counsel and the defendant are present.
Thank you. So before I begin, I'd like to speak to our audience members. I understand that this case has generated a lot of passion and emotion, but you must remember that this is a courtroom and not a sports arena. When I announce my verdict, you must not act out emotionally or visibly or audibly react. So you should leave the courtroom if you believe that you will be unable to maintain your composure. I'd like to start with a few introductory words. Let me say this, this is not in my script. This has been one of the more exhausting, hardest things I've had to do as a judge, as an attorney. And so, as the lawyers know, unlike when a judge presides over a jury waived trial in a civil case, there is no requirement that a judge explain their reasons for reaching a verdict after a criminal bench trial. I do so in this case because I think that Ms. Fitzsimmons, Officer Noonan, and all the people involved in the tragic events of June 30, 2025 deserve an explanation. Next, I'd like to take the opportunity to publicly thank and commend the attorneys in this case. They all did an exceptional job presenting the evidence and conducting themselves in an extremely professional and civil manner. And they did so under the public spotlight in an emotionally charged case. I commend you. To the extent that any of the prosecutors and attorneys may be vilified or subjected to public scorn for simply doing their jobs, in this case, I say that any such scorn is unfair, unwarranted, and simply wrong. These prosecutors and attorneys fought hard to perform their solemn jobs fairly with the utmost civility, and professionalism. They serve as a shining example of our adversarial system in operation. Now, I'd like to publicly acknowledge the crucial and often thankless role that police officers perform, a role that Ms. Fitzsimmons herself, like Officer Noonan, willingly and selflessly performed for the citizens of North Andover. For this, you should be thanked, not disparaged. For those that think that serving as a police officer is easy, or that officers don't care or take pride in their work, I say with more than 3 decades of experience in the criminal justice system that you are naive, misinformed, and sadly mistaken. The work of police officers is especially fraught with peril today because of our exceedingly cynical, polarized atmosphere where our citizenry often believes that there is a conspiracy under or around every corner. I saw no evidence of a conspiracy in this case. What I saw was dedicated public servants like Officer Noonan and his fellow officers doing the best they could under tragic, rapidly evolving promotional circumstances. What I also saw was a young woman, Ms. Fitzsimmons, who was also a dedicated public servant, react to sudden, confusing, and heartbreaking news. Now let me turn to the evidence and the law. Our system of justice requires me to decide this case solely on the law and the evidence. So the only things I have considered in reaching my verdict are the 98 exhibits admitted during the trial and the testimony of the 11 witnesses that testified here in open court. While it may be cold and uncaring, our system of justice demands that emotion, sympathy, and concern for the consequences of my decision play no role in my decision. As for the law, in order to prove Ms. Fitzsimmons guilty of the crime of assault by means of a dangerous weapon, the Commonwealth must prove the following 3 things. We lawyers call these things elements beyond a reasonable doubt. First, that Ms. Simmons committed an assault on Officer Noonan. Second, that Ms. Simmons intended to commit the assault. And third, that the assault was committed by means of a dangerous weapon. The sole issue before me is whether the Commonwealth proves each of these 3 elements beyond a reasonable doubt. And more specifically, under the circumstances of this case, the narrow issue before me is whether the Commonwealth proved beyond a reasonable doubt that Ms. Fitzsimmons pointed a firearm at Officer Noonan for any perceptible amount of time. What is not before me are the legality of the issuance of the restraining order to Mr. Alain, the reasonableness of the procedure used by the police to serve the restraining order, the legality of Officer Noonan's use of force, and issues regarding the custody of Katie. It is not my place to decide these issues or even mention my thoughts on them. I am thankful for this because my role has been hard enough. What has made my job especially difficult in this case is that by and large, I found the testimony of Officer Noonan and Ms. Fitzsimmons to be credible on the material and relevant points. In my experience, this is unusual and somewhat perplexing. On the one hand, Ms. Fitzsimmons credibly testified that she never pointed a firearm at Officer Noonan. On the other hand, Officer Noonan testified that not only did Ms. Fitzsimmons point a gun at him, that she also pulled the trigger. Both agree that it happened in seconds near a narrow doorway, and the crime scene photos show that the door frame was made narrower by a clothes rack containing police uniforms that was to Officer Noonan's left. The door frame was also made, strike that, the door frame was made still narrower when Officer Noonan used it to take cover when he drew his firearm. During the closing argument, the Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without her ever racking the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber a round would have been to pull the slide under those circumstances. However, even if I assume that Ms. Fitzsimmons lied about not wrapping the slide, it does not detract from the adamancy and credibility of her testimony that she never pointed the gun at Officer Noonan, about which he was equally as adamant that she did. Perhaps the Commonwealth could have easily met its burden if the officers had been wearing body cameras. But under these circumstances, I am left with a reasonable doubt, and I am duty-bound to find that the Commonwealth has not met its burden to prove that Ms. Fitzsimmons committed an assault by means of a dangerous weapon on Officer Noonan, and my verdict is, and must be, not guilty. With that, I will hand the signed verdict slip. I will hand the signed verdict slip to Mr. Wayne and ask that he advise Ms. Fitzsimmons of her statutory rights.
Ms. Fitzsimmons, could you please stand? On docket 2025, 77 CR 311, count 001. The court having returned a verdict of not guilty, the court orders it to be discharged of this indictment and this indictment only, and go thereof without delay. Kelsey Fitzsimmons, as required by statute, I must inform you that the records regarding the charges for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you may use the request not to seal form posted on the trial court's webpage on mass.gov, or a copy of which I will hand to your counsel. I cannot accept the form hearing court. You must submit it to the Commissioner of Probation at the address provided on the form. You understand?
Yes, I do.
Thank you. Court is in recess.
Good, all right. Please exit quietly, and thank you once again. Thank all. There are other sessions still going. Please be quiet on your way out. Folks, if you don't mind, stop walking over to the back door here. Also get out. Tight space here.
Love you, Kelsey.
Folks, make your way out. Say that again, Jay. Code 1 is also still. Everybody should be trickling out. Some of you guys want to start going down so that we can get people moving. Folks, I don't mean to put speed to what you guys going on here, but yeah, other places we need to be as officers. So, please. You guys are more than welcome to use that room. You guys can be in there, reconvene and debrief.
Yeah, I need to get this stuff.
All righty, squad. Well, we all got what we wanted. Not guilty. That was justice today. That was absolutely justice today. Right, Jules? They could have settled this in so many other ways. Did Kelsey have to go through all of this besides being shot? I just don't think so. But I'm so relieved for her. She can move on with her life now. She can go finish law school. Hopefully things can be settled with the father of her baby and she can be able to see her kid. She can get her ankle monitor off. She can do anything she wants with her life now. And that's a relief. I know many of us have said, is she going to come back and sue the PD over this? I mean, my God, they nearly killed her. But we'll see what she wants to do, or if she just wants to move forward. I don't know. I wouldn't blame her no matter what she wants to do. But at this point, they can't call her a violent felon anymore, can they? Yes, Zizi is at her post, watching out the window, keeping an eye on things. Thankfully being quiet right now because she does a lot of barking, as you can imagine. All right, guys. Well, we will recap this on our 3 p.m. show over on True Crime Squad, our main channel. So join us there at 3 p.m. Mountain. And we'll go through everything that happened today and debrief this case. Thank you so much for joining me here on True Crime Squad Trials. And we'll see you over on the main page.